So I was reading that I think it was in the House of Commons Manual of Procedure or in Erskine May's Usage of Parliament book. It actually talks about a remonstration, and it actually gives a definition as opposed to a petition. And in Erskine May's, remember, this is not the law, right? This is just, this is just like the guidance. So it said that the difference between a petition and a remonstration is that a remonstration doesn't have a prayer, right? Whereas a petition does have a prayer. And why that would be relevant is because they're using the words remonstrations as more... Well, it's where the word demonstration comes from. A demonstration is to show something or demonstrate it, right? Like a protest. And if they're trying to say that protests or demonstrations aren't petitions, but they can be accompanied by a petition. But it was trying to make out that you can like send a remonstration into Parliament, but it's not a petition if it doesn't have a prayer. Now, I wanted to explore this because the prayer part of a petition is in asking for something, right? Because I was really interested in dissecting the petition. So at the petition, you've got the address to who it's to, then you've got who it's from. And then it usually says humbly showeth. Now that is like your evidence, your statement. Well, it is it's facts, okay? Facts, evidence, statements. You are really that's demonstrating something. Really, you're demonstrating why something, right? But then your prayer is you're usually asking. So the prayer part is when you put your hands together and pray. When you pray for something, it's almost kind of like a wish, right? You can wish for someone to get healthier, better, or, if you want some financial compensation, if the government owed you some money, or if you've been injured, right? Or you can ask for healing or whatever. But the prayer part is usually the part in asking for something, right? So your petition asks for something. So there's some facts and evidence and a grievance. So the grievance part of it is that, is a complaint, really, because a petition, particularly when it's criminal, when it's a criminal, it's a complaint, because all through the earlier acts, it's set out in acts of law, the form of the complaint is by a petition. So if someone's done something wrong, that's the grievance, okay? So complaint is a grievance, and that is actually set in law. And obviously your prayer part, you can have a complaint against someone but not ask for anything. You can say, John hit me, right? But you might not be, you don't need to ask for anything. It's just you're reporting it, right? And then you might set some facts out. You say, you could say, John hit me, and then you could, put a photograph of a bruise or something. Or you could say, like, someone signs it to agree with you that they witnessed it or whatever. That is like fact statements and a complaint or grievance. Now, this is the thing. They're saying that a remonstrance doesn't have a prayer attached, so it's not asking for something. Now, if you've got a criminal complaint, usually you want them arrested and punished, but you might not ask for them arrested or punished, but that's what the law says they've got to be arrested or punished, right? But also in Hansard and in the Manual of Procedure and in lots of government books, it says that petitions present accusatory evidence, right? Can have accusatory evidence. So that's a complaint or grievance, right? If you've got a grievance, someone has done something wrong, that's accusatory. It's accusatory, right? Like you did not follow this procedure properly or whatever, right? Now, the reason I want to explore is, are they right in Erskine May and in the Manual of Procedure? Are they correct, or are they misleading us? Does a remonstrance have a prayer attached or not? Well, I actually think that a remonstrance can have a petition attached, it can have a petition with it, but it doesn't have to have a petition with it. And I think that's where they've got it mixed up. A remonstrance can be with a petition or without one. So what I thought we'd do is, I thought that we would actually explore the word. Let's look at the dictionary and see what the word remonstrance means. And if we can't find any meaning for remonstrance or remonstration, we'll look at demonstration, right? Because those two words, a demonstration is almost the same, except with, it's like the start of the letters is an R instead of a D. Remonstration, demonstration, right? And why we need to explore this is because in the 1661 Tumultuous Petitioning Act, which is one of the main acts of law which define, it's probably one of the most earliest laws which tackles assemblies in public, right? And it groups them in with petitions to Parliament, and it includes a whole list like remonstrations and petitions in a list of items that can be addresses to Parliament. So what it does is it defines something to Parliament, right? Matters, affairs brought to Parliament by petition or remonstration. Now, you can have a remonstration that is not to Parliament, and you can have one that is. Like, you can have a lot of people at a music festival, and, an incident kicks off, and then the police turn up and push everyone out. And then, like, a dispersal order, right? And then all those people might protest for being taken off the music festival, and they might protest that they want to get put back on there, right? But that is not an address to Parliament. That is just they're remonstrating against the police, right? You could have 100,000 people, or 20,000, or a O2 arena, and you could have the same at the Olympics, right? You could have the Olympic Games, or you could even have a marathon. You could have a marathon taking place, and then a lot of people just decide that they want to stop it for whatever reason, and they just might want to stand in the middle of the road, right? But it might not be an address to either Houses of Parliament or the King. So, or you could just have loads of youths in the street who want to, block the street or make noise outside someone's house. None of those are an address to either Houses of Parliament or the King. Now, this is where the confusion comes in with the Public Order Act, right? The very first Public Order Act says that if anyone's arrested under the Public Order Act, they've got to be assessed so the Attorney General can check, see if they've got any political objects, right? Because political objects could confer, if it's a petition, if they are doing a petition and it's a remonstration to Parliament, they might be protected, right? Now, the first Public Order Act in 1936 or around then, right? Remember, they still had the Tumultuous Petitioning Act. So, 20 people could remonstrate with a petition and be protected under privilege. They've got a lawful right to do that at the time. But if there was over 20 people and they hadn't got consent from a court, then it would actually be a tumultuous assembly, and that at the time wasn't a criminal offence, right? Because of the Tumultuous Petitioning Act until 1688, right to petition, when the whole thing started to change. And remember that act was repealed in 1985. But what it did is that you couldn't have large remonstrations which carried privileges with them without first getting the consent from a court. But once you got consent from a court, and it could be a jury, it didn't have to be judges, it could be a jury, then you could have very large remonstrations which were fully privileged and protected. But without the consent from a court, you could still have it up to 20 people. Now, individuals can do it separately, but once individuals start to come together and there's evidence that it is one issue or matter forming, then there were alarm bells ringing. Now, after 1985 and 86, with the Crown Prosecution Service being formed, they scrapped the Tumultuous Petitioning Act. So then courts didn't get involved in matters to do with Parliament, and you didn't need the consent anymore. But what they did is they started to pretend that they wanted everyone to forget about all of that. They wanted everyone to forget about tumultuous petitioning act. They wanted to forget about usage of Parliament, and they just wanted people to think that, you know, all remonstrations, all protests were just to be treated as the type that I explained. If you're just at a music festival and an incident kicks off and everyone gets, you know, thrown off by the police, but then they start demonstrating and, you know, the public sort of form a big group and, like, you know, start demanding that they get let back on again, and that is how people like Priti Patel and the government, the new governments now are wishing and hoping that we didn't click on and remember that you can have privilege protected ones if there's a petition with them to the House of Commons or Lords or the King, right? So let's explore the meaning of these words, right? Now, so I first checked the oldest dictionary that there is to check that I know of, beside that Caldwell's chart or whatever it was, and I don't think there aren't many words on that anyway. Remonstration is definitely not on there for sure anyway. The oldest dictionary I've got is Samuel Johnson's, okay? And remonstration is not in Samuel Johnson's dictionary. But there is demonstration. So, demonstration is the closest thing to remonstration in Samuel Johnson's dictionary, okay? Now, in Samuel Johnson's dictionary for demonstration, it says the highest degree of deducible or argumental evidence, the strongest degree of proof. Such proof as not only emphasizes the position proved to be true, but shows the contrary position to be absurd and impossible. Indubitable evidence of the senses or reason. So it's actually to demonstrate something. I think most people in their minds, when you go to school and then college and then, you know, if you go to university or whatever, but I'm pretty certain that most people in their minds, when you're talking to them, when they use the word demonstrate, I'm going to demonstrate how a kettle works, right? They actually only use it, I think, mainly as a term which they're thinking of as to show you. So the word showeth, right? And that the word showeth appears in petitions. It's very important because then you're going to have evidence, right? So to demonstrate something, I think most people consider that word that they're just going to show you how the kettle works, right? So if you're in college and okay, then John is going to demonstrate, you know, how this Bunsen burner works. Most of them actually use the word and think of it in their minds. Maybe I'm wrong, but as in, he will show you how it works, right? But actually, it means a lot more than just showing someone something. To demonstrate something, okay, someone is going to, you know, demonstrate a fire extinguisher, right? But obviously, when they demonstrate the fire extinguisher, most people just think that they're going to show you how to use it. But obviously, if it's a professional fireman who does it, he's going to show you how to use a fire extinguisher to a very high degree and level, right? Because if he didn't, if he was very rubbish at using it, it wouldn't be a very good demonstration. So I think when in reading this, the highest degree or deducible argumental evidence, the strongest degree of proof. So to demonstrate something doesn't only mean to show you it. So it means a lot more than that. And I don't think that most people think of, when they use the word, that it's just going to show it, but it's actually to show it to a very exceptionally high level or strong level. So the demonstration actually is the most powerful evidence, right? So, I mean, obviously, therefore, if you've got a lot of people who turn up in a massive crowd, and they're saying, to the Prime Minister, reduce the tax on golf balls or something, right? Apparently that is the highest possible evidence, and obviously the more people you've got, the more stronger the evidence, according to that. This is basically a strength in numbers. And it's like when you get people to sign your petition, therefore, the more signatures, the stronger proof. But you might actually be able to prove something to demonstrate it without people or numbers of people, right? You might be able to just show it with a fact from somewhere, like a university fact. The university fact might be unequivocal evidence that, they should, I don't know, you know, you know, ban sandwiches or something, right? There could be some university study or whatever, it could be, but the university study could be demonstrating very strong evidence. It doesn't have to be people, but at the end of the day, signatures in a petition or people showing up it's still evidence. It's only evidence, but it's evidence that is going to demonstrate strong evidence, right? But the people is signatures of the people or their bodies, their physical presence, their bodies is evidence, right? Now that means that it's proof. So let's go back to what we said, what we were looking for. Is a remonstration something that is without a prayer? Well, my first thought was this when I read that it said a remonstration is without prayer, because I thought if you've got a lot of people together, why are they all together? For what reason? I mean, are they asking for something or not? Because you don't have a lot of people there together usually remonstrating if there's not something they want, right? Is there something they want, or is there something they're asking for? Because if there wasn't something that they wanted the government to do or wanted anyone to do, then they wouldn't be together. For example, with that O2 Arena example, if there's an incident at a music festival and everyone gets thrown off, the remonstration is usually going to take place because they want to get back on again, right? They want to get back into the concert, or they wouldn't be all forming a body, a big group, and shouting, So that I can't see how it cannot be with a prayer, because if it was without a prayer, they won't be asking for anything, right? They won't be asking for anything, or they won't be wanting anything, right? So they're all praying to get let back on again. But it's the fact that there's a large body of them, such a large body, that it is a very high degree, and it is very strong degree of proof that they want to be let back on again. But if it was just evidence that, it's such a large number of people that it's very strong proof, but proof of what? Just proof of it's a demonstration that there is a very large a demonstration to demonstrate strong reason or strong strength or compelling, but compelling what? So it's a large group or body that just is compelling. This is a very compelling body of people, right? But if that body of people didn't want something or weren't asking for something, then you could say, but they're without prayer. But they usually are, because they wouldn't have formed such a body if there wasn't something they wanted, right? So I can't see how a remonstrance can be without prayer. It could be without a petition, though. And this is when we're going to get through these, right? So we'll go on to the next one. This is the 1828 Webster's Dictionary, right? So the 1828 Webster's Dictionary, remonstrance, to show something or discovery. It says that's not in use, but so it's got the word show, showeth, or reveal. So discovery is to reveal. So they're going to reveal ourselves, show something. So if you were writing a petition and, you know, you write down some facts or evidence, then you know, the Parliament are going to discover something because you're reporting it to them, you're telling them. If you report a crime to the police or write a statement, then the police will discover something, right? So, showeth. So, in this 1828 dictionary, it's all about showing or the other party discovering something, right? It also says expostulation, strong representation of reasons against a measure, either public or private. And when addressed to a public body, that's like Parliament, right, or the King, or the Department of Transport, or whatever you want, a prince or magistrate, it may be accompanied with a petition or supplication for the removal or prevention of some evil or inconvenience, a party aggrieved, pressing suggestions in opposition to a measure or act, as the remonstration or conscience or of justice, expulsory counsel or advice, reproof. So again, it's still it's a strong representation, basically. But it actually says reasons against a measure, either public or private. But now this is when it says it can be accompanied by a petition. So this is really important now when we've got the Public Order Act and we've got these large groups of people getting arrested and prosecuted, because you can have a strong representation, right? It's the missing key, exactly as it says here, right? This is what we're looking for in the Public Order Act, right? At the time of 1985, when the Crown Prosecution Service was formed, there was an act, the Tumultuous Petitioning Act, at the same time as the Public Order Act. Both existed together, and you could have a remonstration that had a lawful petition there and conferred immunity on a certain number of people, or on all of them if they'd got a court order. They could all have got privileges. Now, at that time, the Attorney General had a duty and role to check, because if they prosecuted people when they were privileged, then that's a contempt offence by the police and prosecutors. Now, in 1986, they repealed the Tumultuous Petitioning Act, so you didn't need consent from a court. That means that it wasn't restricted to 20 persons automatically. It meant that anyone, they could gather together, privileges could be granted to infinite number of people in a body, right? If they've got a petition. But they might not have had a petition. Now, this is the thing, you know, this is why the Attorney General's got to find out what's what and check, or the Chief Police, right? And what's happened is they aren't doing, and they didn't, and they just basically try to forget about it and pretend that it didn't exist. And this is now when you've got Extinction Rebellion and Just Stop Oil and Stop ULEZ and Insulate Britain and all these other groups, right, who are remonstrating and demonstrating, and a lot of them are getting arrested sometimes and put in prison. Now, the Attorney General is not checking, the police chief is not checking for petitions which confer protection, privileges at all. And this is what we're going to try and get them to do. And it's in the last 40 years, right? And it says here, this is in 1828, this dictionary. It says here, this is exactly what I've been saying, which is a remonstration can be with a petition. And that means that it's to the government. But can you have a remonstration that is addressed to the House of Commons or government and can it be protected without a petition as long as it is to the House of Commons or the King? Is a remonstrate? The question is, if a remonstration is to either of Houses of Parliament or the King, is it privileged or not? Now, I don't think Erskine May, I'm not sure if it's clear of whether or not a remonstration is privileged or not. But it does say that a remonstration is not a petition because a petition has a prayer. I find it hard to believe that a remonstration isn't asking for something and doesn't have a prayer, right? But what I think it's likely that a remonstration can have a petition or not. But the group of people usually are wanting some sort of resolution, but they're likely going to be praying for something, even if it's not to Parliament or the King. They're likely going to be praying to be let back onto the stadium, right? And there's a good example in Doctor Who of that, in one of the new Doctor Who's. I think it's the one, 46 Yards or something like that it's called, when there's a strange football pitch or something, right, with no one on, and there's a lot of guys walking around with guns, right? They're trying to make that point, right? So, I don't think Erskine May book is right. I don't think it's correct, because what it is if one person wants to be let back onto the music arena, right, they're not privileged. But then if two want to be let back on, and then three, then four, they become a small body, there is a prayer there, in my opinion. And what it becomes, it's the number of persons that make it into a remonstration. Because remember, through all these dictionaries so far that we're reading, the remonstration is the strength and power behind the presentation, right? Behind that, they're showing strength or they're showing power, right? But they're not showing raw strength and raw power for no reason at all. They're usually asking for something, like praying to get let back on the arena. But that's not privileged, because it's not to the House of Parliament or the King, particularly asking for something, through the government officially, right? They could do that, if they all went outside the Department of Transport, maybe, and said, right, we want, to get rid of electric cars, right? And they were all singing it. Then they're praying for it, and it's a very strong, powerful demonstration, representation with a prayer in matters of church, state, or law. At an arena or festival, it's not. And so it has a prayer. Now, the only example I can think of now which does not have a prayer would be like a random riot, or, like in France. Well, I think in France, they had all those crazy sort of riots and unruliness. They were all kicking off. There was a reason for it. They were kicking off because of Macron, right, and his government, and they were showing their displeasure. There was an official recognised reason for it. Oh, yeah, it was because of the working age that Macron said that, and before they get their pensions and retire, he added a few years onto it extra. So they had a political reason for doing that. Now, you can have it when it's not, because you might have... This is like the word chaos, right? The word chaos, or random, or unorganised. So you're going to have, like, mischief, right? The word mischief. This is when you get the word, right? They've got this word called malice, right? Malice is without cause, without reason. So if the government are annoying people and charging too much money, people have got a reason to petition, right? They've got a reason. But if everyone's just, going around kind of casually putting windows through, because they're bored, that's malice, right? Now, if people, just went around breaking things maliciously, right? You could have, you know, an whole town sort of breaking things or going unruly, chaotic, or rioting. It might not be for any particular reason other than, I don't know, boredom, or they might be goading people or somehow getting pleasure out of it. You know, I don't know, but you can have it. Maybe football yobs, but football yobs usually, you know, if they've lost the match, they're angry, you know, or if, you know, but you can have some disorder. It's called disorder, and I think that word's actually just helped me, disorder, because the word disorder is that there is no order. Now, if you're doing a petition, a remonstration of people who are all praying for one thing, and they've declared that it's to Parliament or addressed it to Parliament, and they've defined what they're asking for, and they're showing in strength of numbers, that is order. It has an order to it. In fact, their formation is orderly, right? Because disorder is not in order, right? If I had a petition with it, like in this is saying, then they went through the procedures to get it in the order, right? So the only questions remaining, which Erskine May kind of glosses over or leaves out, is it doesn't say whether a remonstration is privileged or not, but I think it does say that a petition is not a remonstration, right? But I'll have to check on it again. But now let's just go through a few more of these meanings. So this is another Webster's dictionary. This is the 1913 Webster's dictionary. And for remonstration, it just says the act of remonstrating, a remonstrance. So that's just actually referring to what we had here, because this is also the same dictionary, but it's the 1828 one, where this is the 1913 one, right? And then here we've got, this is the 1913 Webster's dictionary again, to remonstrate. So remonstrance, it says that it's remonstrating, basically. So it says, remonstratus, remonstrati, monstrare, to show. It even links monster here, to point out, to show clearly, to make plain or manifest, to prove, right? To present, urge reasons in opposition to an act, measure, or any course of proceedings, to expostulate as to remonstrate with a person regarding his habits, to remonstrate. So this actually suggests that it's just the showing part. Now, to make it clear, plain, or manifest. So that's almost like evidence. So that would suggest, like, in your petition on the part when it says showeth, right, you are exhibiting, the word exhibiting. It's like your evidence, you're proving. So that's the part that is showing, right? But that also can be the grievance as well. But it might not necessarily be asking for something. So, but also in this section it says to oppose something, right? Now, this is where I'm thinking maybe you can have it without a prayer. You might not be asking for something, because the government might have done something, right, and you might just oppose it. Now, in a way, you are kind of really asking for something, because if someone's done something like, you know, lowered or raised a particular tax, and you oppose that, you're pushing against that tax, you might not need your own particular prayer, or there might not be any new or additional thing that you're not like coming along with something that you want, like, oh, I want a bunch of flowers, or I want, £20 or whatever. the matter or issue or reason is actually evident from the other party, right? So the other party have lowered the tax, right? And that issue, that matter, that concern is already present or presented, and you are pushing against it, right? So although there's a willpower against that, it's not necessarily a prayer for something that you've come up with or your group's asked for. It merely is evidence and force of itself, great strong evidence and force and proof, just in opposition against that thing which is present, which the government have done, right? It's almost like the pushing of one hand against another, right? It's like you haven't come to the other person saying, oh, I want a bunch of flowers, or I want £20, or I want this. It's simply when a person puts their hand up and you push against it, and they're pushing the tax towards you or pulling it against you, and you simply put an opposing force on, it merely is a demonstration of strength and will, merely in an opposing force to their hand, which is already present. So, I mean, it's not something brought in that the group has introduced themselves to pray for. And that's very interesting, the word prayer, because when you put your hands together, you're praying, right? And when you have a remonstration, you're pushing against something, right? So that's very interesting that you put your hands together to pray, or you can push a remonstrance against the government who are doing something, but you're not particularly coming there with a brand new topic, like, I've invented this or that, or I want this or that, which isn't already something that's up for discussion. But most things are the things that the government already have, right? Or have already done, or already exist. But you can have petitions for brand new things, which haven't even been legislated on yet. Like someone invents, all these computers or AI, and there's no legislation around it. It's a brand new invention, and you're merely, praying for some legislation around it. So that's another interesting aspect to it. And then here we've got, this is the 1828 Webster's remonstrating, participle present tense, urging strong reasons against a measure. Right, so that's effectively what I've just said, but putting it even more simply, strong reasons against a measure. That perfectly explains what I've just said, in my opinion. That makes it even more simpler without me having to go on and on about it. The measure had already been put to measure by the government, and it's merely strong reasons against that measure, right? So, that is my for remonstrance, right? So it needed to just kind of explore that for a little bit. So the final question, I guess, is a remonstrance to either Houses of Parliament or the King privileged? Because it's to either Houses of Parliament or the King. It would suggest in the Tumultuous Petitioning Act that it would be. Because it's grouped in with things that you can do to either a House of Parliament or the King, right? But in the 1688 Bill of Rights, it does not say that it is the right of the subjects to remonstrance, and all prosecutions and commitments for doing so are illegal. It only says petition, okay? But what existed before that, there was parliamentary privilege already in place before the 1688 Bill of Rights. Okay, parliamentary privilege existed, and people could do remonstrances to Parliament, which is why the 1661 Act needed to be made. So there is an argument for pre-existing privilege of remonstration before 1688, but there isn't any explicit law which says that is the right to remonstrate. But this is the thing. Therefore, if we go back to this here, which says that a remonstration can come with a petition and a petition can accompany it, then if people are signing the petition and the remonstrant is asking other people to sign it, then they're all privileged. And I think this is where we are with it now, with the courts. This is where we are now with it, with the barristers and lawyers and solicitors, because the barristers, lawyers and solicitors, since they've lost their memory, and some of them are new, like Keir Starmer from, around the time this all happened, the big shift, 1985, 1986, when Starmer's coming out of university. This is the thing. What we're having to do is we're having to teach or remind or get them to learn, these lawyers, and that this exists and that you can have it. And that you can have remonstrations which come with a petition and which confers privileges, right? And then you can have ones which don't, and they need to know the difference. But they already knew that in the 1934 Public Order Act, or whichever Public Order Act it was. They knew that. That's why they had to get the Attorney General or the Police Chief to check, right? But there was a lot more restrictions then, because you couldn't. There were certain court permissions needed, and so forth, and that also applied to the newspaper and publishing, because you couldn't put it in a newspaper asking people to sign it and getting large numbers of signatures without that permission or consent. Okay. Because then you're getting more people to support the cause and agree to it. Because in the Tumultuous Petitioning Act, it says that people can verbally agree or consent to things. But later on in the resolutions of Parliament, they start to come out with that, the petition's got to actually have signatures on it, and so forth. But in the Tumultuous Petitioning Act, you could agree, you could have other types of agreement. You could have like a verbal agreements. You see, if those Parliament resolutions were made before the Tumultuous Petitioning Act, then they couldn't have really been in effect. I mean, some of those resolutions, I think, were before the Tumultuous Petitioning Act was repealed. Some of those resolutions of Parliament, or a petition has to have the signature of each person on it. The remonstration doesn't. It can have other forms of consent, and those other forms of consent were still illegal, right? They exist for remonstrations. So those resolutions of Parliament only apply to petitions, not remonstrations, which you can have to Parliament and which do exist. So there's all this. Once you know what it is and what you're dealing with, then it's easy to find out and check, right? But the main thing is that the privileges exist, right? Now, I'm going to actually have a complaint about the Speaker of Parliament, Sir Lindsay Hoyle. Let's consider online. Let's consider the e-petitions website. So here's the Parliament e-petitions website, right? Start a petition or share a petition. Sign this petition, right? Or you can even share it. Look, share this petition on Facebook, email, X, or WhatsApp, right? Now, this is a thing. Now, I can share this petition with anyone I want because we're told to share it. You can even highlight that there in blue. Look, share this petition. Now, this is a published parliamentary paper. Check out the royal insignia, crown copyright at the bottom. This is really hot cookies because this is privileged in law from prosecutions through the courts or police, right? So when we share this petition, Facebook, email, X, WhatsApp, this is a legally privileged document, privileged of Parliament, a published parliamentary paper. Under the Parliamentary Papers Act 1840, you can get a certificate from the Speaker of Parliament if someone tries to prosecute you for sharing it, right? Now, there are two things that I want to also add into this now at this point, right? Now, the first thing is this. I said to the Speaker, Lindsay Hoyle, right, through email, and he got this Ellen Helen Eames woman to reply, right? And I said, we're sharing this petition, right? That's what people are doing in Stop ULEZ. They were sharing the ULEZ petitions, telling people about them, right? And this is the problem with Parliament now. This is our main obstruction from Parliament. This is our main resistance. And they're really trying to lie to us, in my opinion, mislead us and deceive us. Lindsay Hoyle, apparently through Helen Eames, came back to us and he said that he tried to pass off that you can only share this petition online, that you can only share it online, right? So through an email, you can use but it says email, but what email, right? Gmail, Outlook, Hotmail, Yahoo, BT email or whatever, right? Facebook, X. But, if it just says email, right? Well, what type of email? There are many different platforms of emails, right? But it doesn't list them all. What about YouTube? Well, there's Facebook, X, and WhatsApp. They're all social media, but so is YouTube as well, right? So if it doesn't have to say Yahoo or Hotmail, and it doesn't have to say, Microsoft Mail or whatever. It just says email, right? So why does it have to say YouTube for a platform, right? And this is the thing. How can... There is no law in legislation, in any act of law, and I don't think there's any resolution of Parliament or standing order, not even in the 1993 or 2004 resolutions or anything, which says that an e-petition can only be shared electronically. And if they did try to say that, why? No, this is just common sense. But this is now got my finger on the problem with these MPs. Their attitude, their intelligence, and just it's unbelievable. It's unbelievable, right? Who would try to make that claim? Who would try to lead me to believe, right, that you could only share this petition online, right? That would mean that, right, if I'm sat in a room at a library, right, in town, and I'm on the internet and I find this petition and I sign it, it means that Sir Lindsay Hoyle was trying to lead me to believe, right? And he claimed, as a Speaker of the Parliament of the Great Britain and England, right, or of the whole planet, right, English Parliament, right, was trying to get me to believe that if someone was sat next to me, I couldn't say to them, right, with my mouth, do you want to sign this petition? And that wouldn't be a privileged communication. Like when I asked them if they want to sign it with my mouth, even in the library, you're supposed to keep quiet, right? But we might not have to be in a library. We could be at home, right? So if I'm sat in my house, right, and my mum's in the kitchen, I couldn't shout, well, Mum, could you come here and sign this petition? And that won't be privileged, right? Or if you were in a disability centre and people in the room were blind, right, and they couldn't read the screen, right, and you had to read it out to them, that wouldn't be privileged. Or if you got a friend and you're in the public library and you're whispering, it's not loud, right, that there's a petition there, and you said, do you want to sign it? And he said, I'm not sure, I might sign it when I'm at home, right, later, I'll have to think about it or read it later, right, and he hadn't got his phone on him, right, and he ain't got, he ain't got a smartphone or he ain't got, whatever, but he's got a computer at home, that if I got a pen at the library, right, and I wrote, right, www.petitions.parliament.uk/ petition number 63713428 on a bit of paper, right? And I gave him that bit of paper so when he got home he could remember the internet address, that internet URL written down on paper and me giving it to him right, is not privileged, right? And that when he carried that paper home to remember it, so he could go into his house and type it in and remember it, right? That bit of paper in his pocket isn't privileged, right? And that, the published Earl, right, is not a published parliamentary document. The Earl itself, right? And I don't know why Sir Lindsay would attempt. It's the fact that he wanted to try. He wanted to try to convince me that that won't be privileged, or that he couldn't do it, right? And Helen Eames. Now, only an idiot would try and make that claim. Only a fool. And I don't want to insult Sir Lindsay. I don't want to insult him or Helen Eames. But this is like when you go to like a magic show and the magician's trying to trick you, which balls the cup under, or saw a lady in half, right? Or try and deceive you, right? Who, right, would try to lie to you at that level and try and regard you to be that stupid? It's the fact that they even wanted to try. Now, how can people operating at that level of integrity and honesty be working in the Parliament of England? How can they be employed under parliamentary employment and trusted with the keys to the country? How can they lawfully be allowed to work in the Houses of Parliament of England and have control over this country? When in Erskine May, in the page of public petitioning being privileged, that if someone tries to deter you, mislead you, or lie to you in the pursuit of doing petitions, or petitioning, or executing the functions of petitioning, or deter you from the mesny process of petitioning, it is a contempt and a breach of the privilege of Parliament, right? Because they're trying to deter you from doing it. So these people are trying to deter me from asking people to sign a petition with my mouth, right? Or going out to tooting on a street corner in Sadiq Khan's area and public speaking to the public, asking them if they want to sign Stop ULEZ petition. Or it could be launch a public inquiry into grooming gangs. Launch a public inquiry into grooming gangs. HM petitions. Go online or write it down in your notepad. Launch a public inquiry into grooming gangs. Launch a public inquiry into grooming gangs. Like, as if you're not allowed to do it and it's not privileged. Everyone can't even afford a computer. And even if people are walking around in tooting with their mobile phones, I mean, what do they expect you to do? Does Sir Lindsay Oil, right, think that if you're in the street in London, right, and I got this phone on me here, right, this is a phone, right, I've got it, I'm on my phone up and down, right, does he think that if I'm walking down the street in London and I'm on this website, right, and, that in order to share this petition, right, I could get out a USB cable, right, and I could plug it into my phone, but to share it to someone who's walking past me, I'd have to, shake my USB cable and, just turn my phone around and point the screen at them, and then ask them to plug in. I can't even say that plug in, right? Or I had to Bluetooth them, send them a Bluetooth request, right? That I can't actually say, excuse me, sir, I've just signed this petition on my mobile phone. would you care to, I don't have a QR code on me, but, would you care to, type it in? And that conversation is not privileged. The conversation's not privileged. How do I transfer from my phone screen to his without being a human being and transferring a human message? It's just this. It's not only dysfunctional. It's just the concept of it. The concept that you cannot convert a format. It's like, it's almost kind of like it's a miracle that, it can be Facebook, X, or WhatsApp, or that when it says email, that you can have Yahoo, Microsoft, whatever. What about, postal mail? What about printing this out? You see, this is a thing, right? It doesn't say share this petition electronically, right? And it doesn't say that you can only share it by these 4 options. They're just a suggestion. And it says email, right? But what about fax, right? Can you fax it to someone? Can you fax it? Can you take a screenshot of it, right? And email a screenshot? Can you print out 10,000 flyers of this exact screen here and hand them out? This is the thing. Of course, you can have... In the government's vocabulary, in the government's dictionary for words, the word publish, particularly when it comes to elections and referendums and things like petitioning under the agency of Parliament, the law of agency, right? It says that to publish means to make available to a section of the public or the public at large through whatever form and by whatever means, right? Well, these are some of those forms here and means: Facebook, X, WhatsApp, and email. But email, there are various forms of email and various means of email, like Microsoft Mail, Outlook, Hotmail, Yahoo, BT Mail, Gmail, right? So, whatever form of email and whatever means of email, what about forms? Can you share it by an internet form? If someone's got their own website, John's Art Club, and he's got a form on his website, like a web form, like contact the Prime Minister, can you share it by web form? Contact the Prime Minister at number 10. I'll copy and paste this URL into contact number 10. I'll share it by web form. Doesn't say web form under there either, So it's not practical. The e-petitions are hosted on e-petitions, and you can sign it on there. But to share it, to suggest that it can only be shared online is ludicrous. There's no legislation behind that. It's not practical. It removes the human from it. It's kind of like that. There's no human side of the computer. It's like there's just a machine. There are only machines on the planet. Who's going to sign it? And it's a human that signs it. This is the thing. A human being, a living, breathing human being, has to be sat holding the phone. And it can only be signed by a human, a registered human. A device can't sign it. You're not digitally signing it with a device. It's signed by a registered voter. In fact, it's a registered voter, right, who is the elector. And that registered voter, it's the rights of a registered voter, right? It's almost, I think maybe Lindsay Hoyle kind of thought it was like a polling station, kind of like, go down a local polling station and you got to have your card, and then, they've got to tick you off on the list, and then you got to go into the booth, and then you can put your tick in the box, and it has to be with, the pencil they've got and that paper sort of thing, right? But election law and the law of agency of elections is not petition. right? Because the government are providing polling stations. I think that the fact that the government are going out of their way to help you and they've got a website kind of maybe make them think that you can only use that website, right? But yeah, petitions can be on paper, but if you're doing a paper petition, then you're going to have to go and walk around and tell everyone, we're not helping you do that, else we'll be helping you with your petition. We're helping you with these online ones, so, we can't let you, speak to people about them, just a minute. This is not voting in the ballot box, Lindsay Oil. This is not a polling station. If it was, then you'd only be able to vote Labour or Conservative. I can't see Labour or Conservative on this petition. I'm signing as an individual. This is an independent person's petition. Whose is it? This is Richard Hilton's. This is Hilton's petition, right? This is Hilton's petition. And he, as far as I'm concerned, is independent. Now, that ain't done on the ballot box. I'm quite certain, and the thing is that they're rejecting more than half of these petitions, and then even more of the rejected ones don't even get published, right? I don't even think that 2/3 of the rejected ones get published. I think that out of the petitions that get rejected, only 1/3 of those even get put on the rejected list, right? So they're heavily, these are the people who have sort of relaxed the rules or made them less formal or whatever. And this is another, I better not forget this, right? So the petitions committee are rejecting a hell of a lot of petitions because they say that they're not respectful, or they're not to the point, or they're not explaining things clearly, or that it's just a bit cheeky or rude or witty or whatever, right? Not to the taste of Parliament. But yet, the law of agency of the Houses of Parliament and of the House of the Commons, right? This is the thing. Now, I always use this example because it's the best example. It's just the best example, right? Now, this is the Thatcher, M-Thatcher or whatever they're called, their advertisement for the Conservative Party, right? Now, this was on billboards. Look, there's billboard with a person running past it there, right? This is a Conservative advertisement with a little tiny Lilliputian size Ed Miliband in the pocket, right? And Alex Salmond, right, who's passed away now. Okay, here's a picture of it just to prove you that it was a billboard as well, right? Now, this billboard was all over England, right? It could have been outside Sadiq Khan's house, right? Now, this billboard clearly is mocking Ed Miliband. It's belittling him, and it is condescending, and it's having a joke and a laugh at him, right? Now, this is the thing. Now, political parties like the Conservative Party have got big donors. They get a lot of money. They get £5 million donated to them, right? But they've got spending caps in the election. They've got spending caps, and they've got to account for their spending to make sure that it's all fair, right? Now, I said in another video that, Parliament, they claim money back from Parliament. Well, they do. They claim certain money back from Parliament for costs. Now, you've got the running of the election, the skeleton framework of the election, the polling stations, the electricity. Everyone gets a polling card, which is not Conservative or Tory or Lib Dem. It is like government procedure polling card. So it's like government procedure. So that's all paid for by the government and whatever, right? For a parliamentary election, not local council. Now, this is the thing. There are certain things in an election campaign what can be claimed back from Parliament, costs, and the election agent claims the costs, right? And one of those things is certain letters being sent by post, right? Because candidates are allowed to send, I think it's one communication for free. And that's all been in the Representation of the People Act, right? And to do with public ownership of Royal Mail. In fact, I found in the Manual of Procedure and in Erskine May that you can send a petition to Parliament for free as long as the envelope's not sealed. right? So if you send a petition to Parliament, you don't have to pay for the postage. So I've sent them and paid postage, right? I don't know if Sir Jim Hara's going to be, giving everyone the money back from Royal Mail for that, right? And I even talked to Royal Mail about it, and they didn't seem to know anything about it, because I was wondering if, you could, just send. I wonder if you could send one petition communication to everyone or not. They're probably going to argue against that, but it's questionable. But anyway, let's keep going back to the election. Going back to the elections, right? It does say in the Representation of the People Act that candidates can send one communication to all of the electors, right? So without having to go into the party funding, without having to use the money they've got given to them by their sponsors, right? For all these fancy adverts on billboards, they are allowed to send one communication through the post, but they're allowed to, they can design it and choose it, right? And Parliament are going to pay for that, right? So the Tories, the Conservative Party, could, it's up to them, it's their creative license, right? They could send this, could have sent this Thatcher advert, right? They could have had that printed on their communication on the back of it, right? So this little joke card, this little Ed Miliband comedy thing, right? Advertisement for vote Conservative in the election, right? This is what they choose to make a point, right? This can be, they could post that and Parliament will pay for it. They would pay for it to be delivered, right? And you claim it back through Parliament on the election campaign, right? Parliament are paying for it. So so Parliament, right, are paying money to get advertisements like this delivered. Okay? Parliament are using the agency of Parliament, the standards of the House of Commons, the standards of the Petitions Committee, or the standards of the House of Commons and House of Parliament, right? This is the standard. So they're paying for this to be delivered, right? They can pay for this to be delivered, and that is acceptable standards of material under the agency of Parliament. But if I write a petition, okay, if I write a petition on here, right, start a petition, right, if I right, I'm going to start a petition now, and if I put a wash care Starmer's socks, although I misspelt that. Right. Wash Keir Starmer's socks, right? I mean, how, I mean, it's a tiny Ed Miliband, right? It's making a point, and that's how we're going to win. That's how they're going to win and get into Parliament. Little micro Milibands, right? It's a bit of a political point. It's a point. It's to wit, right? So why are they saying that this is not to the standards of the Petitions Committee under the agency of Parliament? But Boris, right? Boris and Rees-Mogg, I cannot get a petition published past Jamie Stone because it's not to the standards of the Houses of Parliament. It cannot fall under parliamentary agency. It cannot become a parliamentary paper, right? Yet Parliament are paying for the delivery of electoral material which is being claimed back from Parliament, are paying for it in elections. They're paying for the delivery of material like this, which is to wit, to joke, to pun, right? So that means that we, the public, right, an individual person, right, is not allowed to the same standards as electoral material under the agency of Parliament. So that means there's a discrimination there. That means that, pint pulling Boris, sheep shearing Boris, Union Jack boxer short Boris is allowed a different standard to what we're allowed through Jamie Stone in the Petitions Committee. He's allowed to make a point to beat his opponent, but we are not allowed to make points to beat our opponents through petitions, which is Labour, which is the Prime Minister, which is Rachel Reeves. These people who, like in Michael Westwood's petition, and also they're not being honest about that petition, about the fact that the Speaker can warrant an investigation into whether or not Labour misled people through their election campaign. But the Speaker is Labour. Sir Lindsay Hoyle is Labour. He's Labour, even though apparently he's retired from partisan politics while he's the Speaker. But we know that he's Labour. Is he going to warrant an investigation into his own party? This is the thing. And there was another thing that I wanted to mention as well. I don't know if I'll remember or not. All right, I've remembered what it is now. So coming back to the e-petitions now, right? Coming back to the e-petitions and coming back to sharing them, right? So some of these e-petitions, right? This one's recognise the production and serving of cask ale as intangible cultural heritage. Now, this, if we go back to my argument and dispute about Lindsay Hoyle trying to convince me that e-petitions can only be possibly shared on the internet, which it's not practical or possible because I am a human, I'm not a machine, right? And I've got a legal right through freedom of speech to share it by voice or write down on paper. Mainly that not everyone's got a computer or got their phone on them. It would be an obstruction. It actually would be under the rules of petitioning, right? Under the rules of petitioning in that Erskine May manual. If they stopped you from being able to convert, the petition into language and speak the Earl to them or write it on paper, that's the hint. That is obstructing the sharing of the petition, right? And that actually is a contempt because that would try to hinder or obstruct petitioner under the law of Parliament. Trying to obstruct or hinder petitioners is a contempt of Parliament, right? So to try and convince me that is a contempt of Parliament, right? Because it's obstructing me from sharing the petition. I'm not a machine, Now, let's just go talking about online sharing, right? Even if we can only share it online, right? And this is where it really gets mind-bending, right? If you could only share it online, right, and this is a privileged parliamentary paper, and also in the Town and Country Planning Act, advertisement means any representation, legal representation, whether digitally illuminated or not. So it includes being on your screen, right, as well. So if I share this, and you've got to be able to share it on YouTube, right? Now, the Americans have got this Section 230 thing, right? So you would think that, okay, let's pretend that Sir Lindsay Hoyle had an argument, which he completely did not, right? It cannot possibly work. You cannot say that you can't share a petition by turning your head around and asking the person next to you or writing it on a notepad, right? Because that would be hindering and obstructing you sharing the petition, which is a contempt under the Usage of Parliament manual, right? But even if Sir Lindsay Hoyle's claim was true and you could share it online, you would think at the least, if it was only shareable online, and this is a parliamentary petition, it definitely is a parliamentary paper because it's published online by Parliament, and it's definitely got the protection of this 1840 Parliamentary Papers Act, which confers protection from criminal and civil actions against you and prosecutions, right? You would think that out of all the things that you could do on the internet, a petition, that when you do share it online, that it will be fully protected. But this is when we get to this stupid American law now, this Section 230 that they're always going on about, which allows platforms to remove anything and do what they want, right? So the platform, no provider or user of an internet interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So it means that the platform's not responsible for what other people do on the platform, right? So they're not responsible for what other people do. But that means that they're responsible for what they do, right? They're still responsible for what they do if they block, obstruct, hinder, or do something which is a contempt. So you would think that because you're protected by the Parliamentary Papers Act, and because it's a contempt of Parliament to obstruct, block, or hinder someone doing a petition, then the platform, if they take your material down, then they've broken a law, right? That's criminal, and not just criminal, a contempt, right? Because that's got nothing to do with any other party. They took it down, right? Now, this is what I learned about this Section 230, which I didn't know before, and that is this bit here, which says, right, for Section 230C2 further provides, and I don't know why it would say Good Samaritan in an act of law, because, you know, Samaritans are there to help people, you know. You're talking about serious constitutional law and contempt now, not being a good Samaritan. You know, you can't go into a courtroom and headbutt a judge or, you know, walk around the court and throw papers around and say, oh, I'm sorry, you know, do you want to be a good Samaritan and let me off? They'll say, no, that's contempt, you know. Oh, sorry, I was just being a good Samaritan, I was helping you, you know. Can you imagine if you're in a courtroom, right? And you walk over to, like, the barrister from the prosecutor and just pick his papers up and start, you know, neatening them up and tidying them up and say, oh, they're a bit messy. Just a minute, get off my papers. And then the judge tells you to sit down and say, oh, I'm just being a good Samaritan. You know, no, you walked over to the prosecutor and started moving his notes and looking at them, right? Or can you imagine if you went down the jury and someone's shirt were hanging out and you just tucked it in? Oh, I'm just being a good Samaritan, right? I'm just being a good Samaritan. No, you get done for contempt of court, right? So, how? And this is a Bill Clinton act. This is a Bill Clinton government act. This. Why is he using the words good Samaritan? I don't know. So, you know, I mean, I've read some acts of law in my life in England, but I've never come across any language like this. It's almost like it's almost like when they refer to that Copyright Act as the Mickey Mouse Act or the Sunny Act or whatever, right? You might as well just you can't have a serious act of law which tells you something about good Samaritans. In fact, is this an advertisement, right? I've seen acts of law, but like Keir Starmer's got an act of law, right? Keir Starmer's got an act which is like Keir Starmer's personal pension plan. I've tried to get it repealed, but they won't publish it. They won't, and I know that it's just going to get 10,000 signatures and then 100,000. Like, I know that it will get them signatures. I've never had a petition that I've just got loads of signatures before, right? Not massive amounts, and I know that would do it. And they're blocking me and obstructing me from doing it, right? Because you know that I'll get them signatures, right? I've never seen an act of law. Well, you can have private acts. You can have private acts, right? You can have like private companies can have acts of law, like, you know, this certain shipping company only has to pay a certain amount of tax, right? So I suppose that you can have like a private. It's almost like getting free advertising, isn't it? If the company gets mentioned in the act or the individual, it's almost kind of like publicity, isn't it? But I've never seen the Good Samaritans, and because the Samaritans are actually religion. It's actually a religion and a charity, registered. So, and this isn't even a private act. It's not even an act for them, right? So I don't get how Bill Clinton has managed to pull it off where he's giving the Samaritans a free advertisement in a public act of law and not even a private act, not even a private bill. I mean, you'd have thought Microsoft or Bill Gates has had private acts of law put through. Like, Microsoft don't have to pay, 10% tariff or something like that, right? Or Microsoft gets VAT exemption, right? Oh, he's getting a bit of publicity as well. But that's a private act, right? Is this a private act or a public act? Is this an act for the Samaritans? In a public act of law for everyone online, Bill Clinton is giving the Samaritans a free advertisement in an act of law. And it's also a religion. I mean, I have not seen anything like it in my entire life, And maybe it's just the language of Yanks, they're a bit loose, a bit wild. Yeehaw, an act of law, Mickey Mouse, Good Samaritan. It's just the way we talk, You might as well call it provides wacky Michael Jackson wacky Jacko protection. I don't know. Maybe they might have just why not put Satan? Why not mention Satan in there? I don't know. Or they could have even put Jesus in there and advertise the Bible. But the good Samaritans. I mean, what is that? It's a religion and a charity, and they don't get free advertisement in an act of law. But anyway, further provides Good Samaritan protection from civil liability, right, for operators of interactive computer services, that's YouTube or Mark Zuckerberg, Facebook, in the voluntary good faith removal or moderation of third-party material the operator considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. Well, that's just saying that it can remove it for any reason or no reason. And some of them have got that policy, any reason or no reason, like TuneCore, right? But that policy is saying that they can remove it for any reason. But can they have an illegal reason? If you've got a policy which says any reason or no reason, you're claiming you can have absolutely any reason, even one of those protected characteristics like sex, race, gender, religion, right? Which you can. And there's a legal right to enforce that law of discrimination by intervention, upholding the law, right? So they can't have that any reason or no reason policy. They just can't have it. Now, this is a bit like it. It's saying anything which is otherwise objectionable. Well, protected characteristics aren't objectionable. They're not objectionable in law, right? Because they're not. Because it's illegal to objectionable to it, right? So it's a crime. So you can actually enforce the law and stop the platform from removing it, right? But it goes on to say here, right? Filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Now, this is the big thing. Whether or not constitutionally protected. So it's trying to make out that if you've got political material in America under the First Amendment, that they can still remove it. And I think this is why Robert F. Kennedy Jr. lost his case with this Judge Thompson, right, in California, because of this constitutionally protected thing, because Judge Thompson in California thinks that they can just remove anything. There is no constitutional protection. But is constitutionally protected also those protected characteristics like race, religion, or whatever? Because they're not otherwise objectionable because they're actually illegal, right? Now, it's a bit of a ridiculous situation if the American government, Bill Clinton, at some point decided, right, that, hey, what we'll do is laws which are blatantly illegal and not otherwise objectionable, like protected characteristics, race, sex, religion, have got more protection than constitutionally protected things. That means that if you're petitioning Bill Clinton, to, abolish his tariffs or whatever, a woman, for being female, is more protected from being removed because it's not objectionable, because it's a crime, than a constitutionally protected thing. So that means that a woman, right, for being female, cannot be removed from a website. She's got more protection for being a woman than someone has got for trying to change the laws of America, right? Since when did women... that means, effectively, that if you're a man, right, let's try and get a petition that involves women, like tampon tax, right? Okay, tampon tax is only women are going to... It's for women, right? That means that a woman doing a petition like let women into men's toilets, right? Because women are doing if you've got a group of women who are petitioning for women to be a woman's law, like women, a new law for women, right? That because it's a law for women, right? That it can't be removed because it's a protected characteristic. So if women were petitioning the White House for, the right to wee in public, right? Okay, let's say women want the right to be able to just squat and wee in public, right? Take a piss, right? Because usually it's indecent exposure. Let's say women wanted to be exempted from indecent exposure in public if they needed to take a wee, even if there's no lavatories around, even in the city and even in California, any state, right, that if that petition gets taken down because it's about women, it is not otherwise objectionable because of protected characteristics. Because the protected characteristic of being female will protect them more than the constitutional protection that it is a petition to the White House. That means that women have made themselves as women more constitutionally protected than petitioning. So, if you've got men and women doing a petition to get rid of Donald Trump's tariffs, they haven't got any protection, right? But a woman petitioning to be allowed to take a piss in public, like, how about Hillary Clinton, right? And it not being an offence anymore, cannot be removed from a platform. Because it's not otherwise objectionable. Right? Because it's a protected characteristic, being female or something, right? Maybe that argument won't stand up. But this is the thing. Anyway, regardless of all that, this constitutionally protected bit here, so this is the bit what they've been arguing about, all these Americans, about the First Amendment. And one of the lawyers said that constitutionally protected material is protected online. But this is what Neil Mohan has been using his Dutch courage for, and Sergey Brin and Mark Zuckerberg. This is those words there. This is where they're getting the balls from, right? But I can guarantee you, right? So if you obstruct a petition mezzanine process, a petitioning campaign, right? If you obstruct it, it is a criminal contempt, right? Because obstructing illegal processes are criminal contempts. A civil contempt is if you do not obey a civil order, right? Like an injunction. If you do not comply with an injunction, that's a civil contempt. If you interfere or obstruct a legal process, even if it's a civil legal process, if you're in a civil court, in civil process, Tommy Robinson is in prison he's under arrest and imprisonment for breaking a injunction, right? He broke a civil order injunction, that's why he's in prison. But if he was in court and he committed a contempt in court to obstruct the proceedings, right? Like what Rob Ratcatcher did. It doesn't matter whether it's a civil proceeding or a criminal proceeding. Obstructing a legal proceeding, right, in a courtroom, that's a criminal contempt, as it is with intervening in a parliamentary petition process. It's a crime. It's a criminal contempt, right? This is what the police are doing against us, right? So when YouTube removes your material, which is protected, that is a criminal contempt against constitutionally protected material. This only removes civil liability, not criminal liability. So that means that Neil Mohan and Carol Vasquez can be arrested and prosecuted for removing the material. I can also tell you that I've told you you've got the right to stop a crime from happening. When there is a crime and an offence, you have got the legal authority to crime prevention, right? To prevent someone stealing the bread, uphold the law. So they can't remove it. Because it's a criminal contempt, you've got the legal right to crime prevention, right? Now, the only civil liability is only for suing them. So if they remove their YouTube channel, according to this, right, in America, you can't sue them. So, like, if they remove your channel for 12 months, like, and, you know, you can't say, right, you owe me, you know, 10 grand or whatever, because they're not prone to civil liability. So you just can't sue them or have loads of people suing them, according to this. But that actually does not give them the right to take the material down, because you've got a legal right to intervene. So they actually can't. I don't think they can take it down. So what this is really doing is saying, oh, the Good Samaritan part of it is the part where it's just tosh, because it's saying, oh, this is completely illegal to do and you can't actually do it, and we can actually stop you from doing it. But, you know, if it's, you know, harmful or hurtful or whatever, you know, we're saying you can take it down, and we're not going to let someone sue you, right? We're not going to let someone sue YouTube and Sergey Brin, you know, for 100 million. Because, like, if he's got a million users and they were all having political material and he took it all down, then by the time we'd all finished suing YouTube, they'd be bankrupt, right? So it's just the money. You've actually, they don't actually have the right to take it down. It's still a crime. And I know in England for sure, but I think it must be in America. I don't know what the equivalent of the American parliamentary law is, because there aren't really any books that talk about it or go on to it much. There's one by Jefferson. You know, there's none of the books that are as detailed as Erskine May's book in England. But for YouTube, at least in England, they can't take the material down. And this law is only for America anyway, right? I'm talking about if this American law was in force in England, right? And my main problem is that, this is my main problem. In England, that law does not apply. It does not apply in England, that law. It's an American law, right? Now, in England, these petitions are parliamentary papers. And if you get something taken down or you're obstructed from sharing, right? If I'm obstructed from sharing this petition here, this embed food farming sustainability education into the national curriculum, right? If I'm obstructed from sharing this on these platforms like Facebook and so forth, right, that is a contempt, criminal contempt. And when there is a contempt, the court that you are with are meant to get like subpoenas and things like that, right? You get the subpoena. Now, under the Tumultuous Petitioning Act, I'm quite certain that when you got a court order, and you put it in a newspaper, you use that court order to get it published. So if you got consent in a petition, then the actual order from the court, because you want to put it in the newspaper, right? That order is like order to publish, right? The order from the court, you actually use it to put it in the newspaper with, right? Because you wouldn't have been allowed to put it in the newspaper, really, if you're asking for more signatures without that order. And I think that order actually, it's like you can get an order to get it published, right? Just like they can get an order, courts make orders to not publish, right? I'm quite certain about that, because that's one of the powers of courts, right? And but Parliament are not helping us. They really don't care. I've asked the petitions committee. I've written to them. I've asked the speaker. I've asked everyone in Parliament, my MPs, my past MP, Mark Eastwood. They just don't do it. I'm saying I need my petition channel put back on YouTube. But when David Davis MP had his channel taken down, got it banned, someone contacted YouTube and it got put back up again, right? So they really don't care about us. It's like a court that doesn't care. Can you imagine if you went to a court and they just wouldn't give any warrants or any subpoenas to anyone? They're just like, no, we don't do that. But it says that you do it, right? Now, in the manual of procedure, they've got all actions like, when there is a contempt, an action when there's a contempt. Well, you can petition Parliament when there's a contempt that you need an action. Well, that's what I'm actually doing. They don't realise that's what I'm doing. When I contact Jamie Stone or my MP, right, or the Speaker, and I say, I need my YouTube channel put back up because it's got my evidence on there and I need access to it, right, and I'm sharing my petitions, then that you're reporting a contempt and there's an action from it, and they're meant to give you a subpoena or a warrant or a certificate from the Speaker that you sent to YouTube to get it put back up, like with David Davis, right? But they're not doing it. They don't care about us. They couldn't give a tiddlywink squiff, and they don't even know that manual and procedure. I've found that manual and procedure recently, right? I know from how Lindsay Hoyle is approached us with this whole thing, that even trying to claim that you got to share it online only, right? When he comes at me with that, I'm like, you got to be joking. You can't be serious. Why would you even try to convince me of that, right? And this is when I know that we're dealing with charlatans. We're dealing with crooks and criminals. Or just they don't know what they're doing. Like, I don't want to knock Jack Rankin MP because I don't know him, but he's a new MP. He's never been an MP before. It's his first time. He's got to be trained up. Now, he might have read a few books and done a little bit of research. He might have been in the Conservative Party for a while. His wife's a barrister. But he just does not know all these procedures and things. And he's not really trying that hard or making much effort, I don't think. And even Jeremy Corbyn, I don't think that he could give a monkey's tiddly squiff chuff. I mean, how long has he been an MP? And he hasn't managed to advocate or prove these privileges for many of the protesters properly. He might have done some in secret and private, but from how Lindsay Hoyle has been dealing with it, I don't think so. It doesn't seem to me like they know all of the proceedings and procedures of Parliament, or else they're treating us like paupers or squiffs. Particularly in the manual, it starts saying, well, since, whatever date, petitions have never taken any appreciable time in Parliament. Well, maybe people, if they start removing all the procedures so we don't know about them, not legally removing them, just hiding them, right? These people aren't going to be doing it as much. This is the thing. And actually redacting the manual and, taking things out of the manual so we don't know about the things that exist is hindering and obstructing us. That's contempt. And Margaret Thatcher did that. Margaret Thatcher, by the time of that 1987 manual of procedure, it's all been hidden. And you got to get the older manuals. So, big business now, parliamentary agents, who can afford a parliamentary agent? All these big companies getting acts and bills put through, getting parliamentary agents, go see your MP, the chance I had to see my MP when it was a decent MP, and he did reply to me, and I think that if I'd have met him, if I'd have known what I'd have known now and met him, I think I would have been able to get somewhere. At the time, when I was going to meet him the day before, I did know quite a bit, but then I never met him because I've never had a surgery with an MP. I've got Barry Shearman to sign some off for me, but Mark Eastwood, he it got cancelled because they locked the whole country down, the pandemic, That's what happens the day before I go see an MP in person. The whole country gets locked down and no one can go out. So, this is the thing. And I'm quite confident that with the material and books and papers I've got now, if it would have been Mark Eastwood in there and I'd gone to see him now, I would get it sorted. Or at least I got a very, very compelling and strong material to put in front of him and ways and means that things can get done. Although you don't necessarily need your MP because you can send in petitions and self-represent. But there are these processes. There's even a process for claiming money back when you've been injured through Parliament by petition. And if you've been injured in connection with another petition or something like that. But you've got to get a you've got to get referrals from the Crown, which I have. I've got a referral from the Crown. So, this is it. But we're not getting any support at all. Even the Judicial Conduct Investigations Office would not try and get my YouTube put back. And the YouTube law that they're using is only for removing stuff from public view. It's not got any license to destroy or delete anything, particularly if it's evidence. And all these acts of law, like evidence acts, it's protected material, and you should get a subpoena to get access to it because another party cannot seize or steal or withhold material which is for legal cases or legal purposes when you need access to it. So Google should let you log in, and at least get your material, and they haven't done that. Parliament even haven't got them to get me my login, and neither have Judicial Conduct Investigation Office when I sent a subpoena, to against YouTube. So we're just not getting any help or assistance because mainly these e-petitions, something that actually is for an individual, for a person. I mean, petitions now are more like begging, it's like the beggar's process, but not when you've got massive crowds of people, right? But now big businesses like Microsoft, like Facebook and YouTube, like these big companies who have got billions, right? They go see parliamentary agents, get some help writing legislation, and they're lobbying and getting bills put through, right? So getting bills put through Parliament, working on bills, they're getting all the protections, all their immunities, working on bills. Bill Gates, it's all big companies with the power now. But petitioning is the poor man's redress through Parliament, and the poor man has privileges. The poor man has a right to claim money owed, whether it's tax relief or whatever. And we're not getting it. And this is a problem with Starmer, right? When people are doing remonstrations with petitions attached outside the Mayor of London's. And the Mayor of London is just prosecuting them illegally. And the police are, right? We are second-class citizens and scumbags now, and they're trying to delete and erase all knowledge of it from the manuals of procedure because we've got no value to us. We're not equal citizens, right? Unless you've got $1 million or $1 billion to throw a parliamentary agent, and get the law changed. These are the people that MPs want to deal with. These are the people that Nigel Farage wants to get handshakes with and get in with. These are the people that Keir Starmer wants to go and meet, walking around the NHS hospital being worshipped like a god or whatever. Not people with problems, people with issues, and people who are calling Parliament out on the processes and procedures when they're trying to mislead and obstruct us and deter us. And it's that deterrent, you know, it's, you know, we have no value, you know, and petitioning is, before these big companies took over, and before these big companies took all the money and had everyone working for them, they were skilled people. And this is what Keir Starmer goes on about, you know, skilled people. You know, my dad was a toolmaker. My dad was a toolmaker, right? But my granddad, you know, was a billionaire in a mansion, you know, in the House of Lords or whatever, right? But my dad was a toolmaker. But all of the people in England, all of the skilled people lost their jobs. And that's why the Luddites kicked off, and they were losing their trade, and they were getting competed from overseas and stuff like that. And this is what all the petitions were about. There was a lot of petitions about trade, a lot of complaints about elections, and things like that. Because they weren't, you know, there were shipping companies and there were these adventure companies, and there were, you know, like, you know, Sir Walter Raleigh and Sir Francis Drake and the pirates and all the, you know, the Virginia tobacco companies and all this. But there were still a lot of skilled people, guilds, tradesmen, craftsmen, and all these type of people doing petitions over things. And then gradually the bomb's fallen out of it because it's all been taken over by these big corporate people. And those are the ones running the parties, like Margaret Thatcher. And that's why Thatcher has betrayed us all and tried to steal our rights, and why we need to uphold them, right? So YouTube have committed a criminal contempt in England, right? And we need action. You know, I want my channel put back up. It's a complaint. It's a contempt complaint. And it is a contempt complaint. And it's a breach of privilege complaint. And, you want to complain about sums of money, you know? And getting compensation from YouTube. They're protected in America from civil suits over a channel being taken down, but not in England, because that section 230 is not an English law. So I can sue YouTube for having my channel taken away from me for 2 years. You know, I can get financial compensation as well as criminal justice against them.